Kay mentioned, we're delighted to be joined by Leslie MacIntosh, who's Corporate Secretary and Acting General Counsel, and she's going to kind of bring all this discussion around digitalisation together with perhaps some of the sort of legal and transnational challenges we have. But before we do that, we've got a short video that we're going to show you to try and put some of this in context. So you can play that one, please.
Every day, 12.5 million people take to the sky. Many of them cross international borders, and every passenger comes with multiple pieces of personal data, which airlines have to process and transmit to facilitate that journey. Some pieces of data are compulsory. For example, many governments require passenger name record, called PNR, and advanced passenger information, called API, which can be used to fight terrorism and serious crime. API data is taken from passports, while PNR data is taken from information collected by the airline or travel agent when tickets are booked. This includes the passenger's full name and itinerary, a phone number, and email. In addition, airlines may collect other data, such as credit card details, frequent flyer numbers, meal preferences, and hotel bookings and car hire. Here's an example of why all this data becomes a complex chain for airlines to manage. Mrs. Johnson has booked a flight for her son Casper on Alpha Airlines. He's flying from Washington, D.C. to Singapore. Alpha Airlines doesn't fly to Singapore, but it does have an interline deal with Omega Airlines, who fly there from Paris. So Casper is flying from Washington to Paris, then switching to Omega Airlines to make the next stage of the journey. Alpha has taken Mrs. Johnson's details as the booker of the flight, and Casper's data as the passenger, and transmitted them to the American government, to the French government, to the Singapore government, and to Omega Airlines. In addition, Casper requires airport assistance, as he is a passenger with reduced mobility. This means that Alpha Airlines must transfer that information to Paris CEG Airport, who provide wheelchair services. And Omega Airlines must make sure Singapore Airport is aware. His return flight requires all this information in reverse. As you can see, the amount of separate data transfers involved with just one passenger journey is already extensive. Airlines work hard to ensure compliance with the complex patchwork of data protection laws, but different governments have different rules for handling data. In fact, over 140 countries have some form of data protection law in place. The EU GDPR regulation, for example, is different to the regulations in Canada, China, or the US. These laws may apply outside of the country and overlap or conflict with laws in other countries. In fact, multiple different laws may apply to the same journey, causing compliance challenges and confusion for airlines and for passengers. This complication makes the chances of error higher and could restrict the potential of personalized options and self-management for travelers. For these reasons, airlines are pushing for data protection laws to recognize the specific challenges that airlines face, particularly when transferring data between states. The International Civil Aviation Organization has recognized this as an issue. It has agreed to consider the challenges and options with a view to potentially developing aviation-informed guidance materials. The goal is simple: maintain the highest levels of personal data protection while facilitating the development of efficient and convenient connectivity.
Great, so hopefully that's put some context around what we're going to talk about today. Thank you, Leslie.
Thank you, Chris, and good afternoon, everyone. I think we've been hearing a lot today about digitalization in the aviation industry. And as you will have seen from this video, I'm going to highlight an important compliance issue that's very relevant to digitalization and the aviation industry as a whole. And I'm reminded that this week is the week that we celebrated the 80th anniversary of the Chicago Convention. You might wonder, why am I mentioning that? Because one of the things that was contemplated when they drafted the Chicago Convention is making sure that compliance issues that might apply in domestic laws were developed in a way that took into account the characteristics of civil aviation. And certainly this is an issue that was not contemplated, as you can imagine, at the time of the Chicago Convention, and when the framework for civil aviation does not, at the moment, have any area where we can talk about some of these things. But this is a compliance issue that is disrupting efficient and orderly connectivity and is becoming increasingly a significant issue for IATA's airline members and the industry as a whole. We all have an expectation that our personal details will be taken care of and our privacy respected when we share it with businesses for any reason. It's important to us all. But first, what do we mean when we talk about personal data? I think that's an important thing to think about. And in that video, you might have been thinking, look at all the different types of data there might be. Personal data is defined differently in various jurisdictions around the world. However, generally, it means personal information that can be used to identify an individual, and anything that relates to the personal characteristics identifiable in that individual. And that, of course, could be things such as your email address, your home address, your passport number, your date of birth, gender, religious and cultural affiliations. So it's quite wide. And in some regulations, some types of personal data, such as health information, receive even more protection. And this is referred to as sensitive data. So what personal data do airlines need to transfer internationally? And we're looking at this iceberg here. Most of you will have traveled to Geneva by air. And to make this journey possible, airlines will have had to collect, process, and in some cases transfer your personal data outside your home country. But what is collected by whom? So we think about this iceberg, and we think, first of all, above the waterline is the personal data that has to be shared with governments. And for instance, as referred to in the video, your passenger name record. Data would have been sent to the Swiss government before your arrival. Another type of safety information that is collected by governments is, for example, flight crew licenses and medical certification of the pilots that flew you here. You will, of course, remember that during COVID-19, sensitive health information was also collected by airlines and shared. However, there's a vast amount of other data required to support your journey, much of which is less visible below the waterline of our iceberg. For example, if you were on a code-share flight, or if you requested a special meal from the airline or special assistance from a wheelchair, for example, your personal data would have been shared with all the relevant parties, such as caterers and airports along the way. And in fact, a special meal request or a wheelchair request could involve what is considered sensitive data about your religion, about your medical conditions. All of these transfers need to be done in compliance with data protection laws across different countries. And with over 4 billion passengers traveling every year, you can imagine the sheer volume of data involved and all the significant compliance efforts required to manage it all. So this is a little bit of a dull slide, but I think there's some interesting information behind it. And I'm going to tell a little bit of a story, a bit of a history story about it too. So the introduction of regulations about privacy rights and obligations to protect information legislation really is rooted in the social changes that came after World War II. That's very dull. I'm very geeky about some of these history and legal issues. But I think it's really reflected in the fact that in the 1960s and 70s, the early countries that adopted privacy regulations were talking about it as the right to privacy. And now, as we've moved on, the regulatory activity that we've seen has been accelerated in large part due to the rise in social media. So we're not just talking anymore about somebody's right to privacy, we're talking about the obligations on organizations that deal with those personal information in various different ways. So currently there are more than 140 countries with established data protection laws. And I think a lot of us remember 2018, that's when the EU GDPR, General Data Protection Regulation, came into place. It set a significantly higher protection obligation on parties that deal with yours and mine information. It also expanded the idea of the right to privacy and actually said individuals have a right to control the use of their personal data, and introduced it as well, extraterritorial application. So those rights continued even if you left your country or left the EU. And that has led to other countries then thinking, well, we need to think a little bit more and a little bit more detailed about data privacy. And some of those countries implemented or amended their regulations to align with the GDPR. Some took steps to impose measures even more significant. And this has made the landscape increasingly complex and challenging for airlines to navigate. More on this in a moment. This regulatory fever, in the wake of growing and more intrusive social media, was developed without considering the special characteristics of international civil aviation that under the Chicago Convention, states agreed to take into account when implementing regulations that impact civil aviation. One of those innate characteristics, of course, is that in order to transport a person across borders by air, their data needs to travel with them. There are several key challenges impacting airlines, and let me highlight just a few of them. Laws are inconsistent. The legal basis for collection and use can be different. For example, under the EU GDPR, explicit consent is prioritized, and individuals are empowered to make decisions on the use of their data with full knowledge of its potential use. In contrast, for example, the Canadian law, which is called IATA, allows for organizations to actually infer consent, imply consent in certain circumstances. It doesn't require individuals to actually explicitly consent. You can say that in these circumstances, consent is implied. It also, the Canadian law places more emphasis on the actions of the organization using personal data and less on this right of an individual to actually control how it's used. As we saw in the video, extraterritoriality means that multiple laws may apply to a passenger's itinerary, and this makes it difficult to determine which law applies. And it also creates confusion for consumers, as they do not know who is ultimately responsible for protecting their data. Not all countries have data protection regimes that apply extraterritorially. And the PIPEDA in Canada is an example of that. It does not apply to Canadians everywhere they are. Laws increasingly create conflicting and inconsistent obligations on airlines, creating barriers to cross-border transfers and ultimately connectivity. Let's look at probably one of the best examples of the issues facing airlines and how these issues manifest in practice. The UN Security Council mandated that states collect PNR data, passenger name records. The UN Security Resolution 2396 was made in response to terrorism threats. It's a security issue. In response, the ICAO established guidance for states in how to collect this data. And by 2018, 25 countries had PNR programs that would require that collection. And today there are 70 countries that have established a way domestically for them to comply with the UN Security Council resolution. However, there's a difficulty, particularly in terms of the GDPR. And I'm not trying to point out that there are issues, of course, with Europe and their regulations. However, it is one of a great keen example of what the challenge is. So carriers from the EU and the EEA states have a problem. The GDPR does not recognize that the fact that there is a legal obligation in other jurisdictions, and the UN Security Resolution is a good example of that. or the fact that you've implemented domestic legislation to put into place that as a valid ground to transfer data. So what does that mean? So it means that you can't transfer unless you meet the requirements of EU law. And that law has two elements to it. The first is that those states have to be deemed by the EU to have adequate data protection laws. And you'll see the list of 15 states that have had that determination made. And you might say, it's kind of an odd list of states. It's not perhaps all the states that you might think should be on the list. But I think the next is even more interesting. And the fact is that in addition to having that adequate law, you have to have a bilateral agreement with the EU. And there's only 3 states that have such a bilateral agreement. So of a potential 70 states that require PNR data from our airline members for security reasons, only 3 have an agreement with the EU to share that data from EU citizens traveling to their country. The challenge lies in the fact that carriers must determine whether they comply with their home country's regulations that say they have to provide that, or they're going to, they have to provide it, or whether they comply with the EU law that says they can't. There are fines that arise from these, and the fines can be very substantial. We've even had one carrier report that the captain of an aircraft was threatened with imprisonment for failing to provide the PNR data on landing. So it's a significant issue. So there's a lot of adverse impacts on airlines from this growing complexity. Airlines have to comply and manage multiple data privacy protection regimes across their networks. This is a significant logistical and operational challenge. You can imagine the IT that must be behind this. There is also a risk that information cannot be shared for critical safety and security reasons. And this is a concern actually for the states, for the countries that are expecting to receive some of this data. Aviation requires personal information to be shared to ensure all of our safety when we travel. It is not clear how these adverse impacts on airlines and on states and on consumers can be balanced with the important right we all have to the protection of our personal information. So now I want to talk about the exciting stuff. And you look at this, that's not very exciting, is it? But I want to highlight something that has happened that for me is a wow moment in the work that we've been doing over the past 3 years to make the issue known to civil aviation regulators and our colleagues at IATA. Over the last 3 years, IATA has been making the case for ICAO to study the interaction of national data protection laws and civil aviation. In November, the ICAO Council approved an update to the work program of the ICAO Legal Committee to include the establishment of a multidisciplinary working group to study the issue and its impact on civil aviation. Fantastic. About time. It's wonderful news. You may be saying to yourself, though, that doesn't sound particularly exciting or groundbreaking. It's just establishing a working group. But it is. I assure you it is. Firstly, the Legal Committee work program is rarely added to over the years. I've been attending legal committee meetings for many, many years, decades, and very rarely is anything added to the program, and it's very significant. This has been. Secondly, the airlines have been heard by states who agree something must be done. They recognize that this is an issue that's not just for airlines, it's for states too. And lastly, and I think really importantly, is we have a very important opportunity. Airlines and states working together with experts on data privacy and civil aviation to work together to ensure that the special characteristics of civil aviation will be taken into account in this challenging compliance issue that is impacting the safety, security, and efficiency of global connectivity. And just to be a bit cliched, I'm just going to say, this is just in the way the drafters of the Chicago Convention would have wanted this issue to be dealt with. So thank you very much.
Thank you, Leslie. Thank you very much. So, after that sort of force, do we have any questions for Leslie on the issue of transnational data and what's going to happen? All right, while you're thinking about it, I'm going to think about it. Yeah, so I apologise that I didn't bring the champagne and the party poppers with this amazing news.
It is amazing.
Of the IATA work.
I think I'm the only. It's really amazing.
So tell me, like, when are they going to start work and what tangible outcomes are we going to have?
Yeah, I think it's a really good question. I think they are. I think everyone was surprised that this has happened, but they're surprised and we're ready. We are ready to help them. We've already started to have some discussions with the director of the legal bureau. When I was in London a few weeks ago, and the Secretary General of ICAO was there, Juan Carlos Salazar, and I spoke to him about it too. They're very keen. They want to get this done. It is interesting to have an issue where we can all work together on. So we would expect to set up meetings in the next few months. We'll start setting up the meetings, getting ideas on the types of experts we will need to contribute to this. It's exciting. We will, as IATA, be assisting. We've offered to host the meetings here if necessary, because it might actually be a kind of a convenient place for people to travel to. We hope to do this, get started on this well before the states get focused on the outcomes of the assembly in September next year. It would be really great if this working group could actually put a paper together for the assembly in September 2025. Our outcome hope is that we will develop guidance material that will be very useful in state enforcement agencies on data privacy, as well as regulators that are considering amending or drafting their legislation, and also for states who are newly implementing. But the dream, so that's the hope, the dream would be this could in fact be something that is ripe for some kind of international agreement, some kind of bilateral agreement. We whisper that treaty word or that international agreement word because that's something that is a little bit daunting. But that's the dream, and we have the hope.
Yeah, well, I mean, obviously dreams and hopes, we all want to see those come to pass. Other than the work with ICAO, is there stuff that's happening with governments, maybe, you know, on an individual basis, IATA working with them to kind of mitigate some of the worst aspects of the kind of challenges that you described?
Yeah, I think there are a number of states that actually are really supporting this effort and have actually worked on their own data privacy and protection regulations in the last few years, and are looking to make sure that they are dealing with those airline, aviation, and state information sharing that needs to happen in their regulations. So that is going on. In addition, there's work across other organizations. The OECD is a good example, where there is a working group looking at this issue across other industries as well. And I think it's important that we look at this across other industries, but I think that we really need to emphasize that aviation is distinct. We're not saying that we need special treatment for some of the issues that might apply in the same way to other commercial organizations. But when we're talking about traveling with your information, either before you travel or whatever, it is very unique. Aviation is a very unique cross-border personal information, very sensitive personal information, because of the safety, security, and other regulations that are under the Chicago framework that apply to civil aviation.
Thank you. Distinct but not special. Yes, yes.
Thank you, Leslie. You mentioned that about 20 countries have no legislation and no data. What about cooperation between ICAO and IATA to help these countries to achieve progress in this topic?
Yeah, I think that's also something that we would see coming out of the working group as well. It would be recognition that there is work that can be done to assist states, and we know ICAO is working hard on that all the time. And I think that this information is really important, and we hope that that will become part of the normal work of ICAO. And when I mentioned, just to clarify too, when I mentioned multidisciplinary working group, I wanted to stress too that there are ICAO experts in facilitation, and the facilitation experts in ICAO do deal with PNR data. They're the ones who develop the guidance material that enables states to share PNR data and airlines to process it. And so they will also be heavily involved, and I know they work with states on how to implement the PNR directive as well. So we think that that's an important part of the work that will be done.
Any more questions? Going once? I think we blew their minds.
I know. Oh, no, is that
Oh, yes. Is that Ian? Go ahead.
Yeah, Ian from Taiwan. I'm a bit surprised by your optimism about the prospects of an international agreement, given, you know, there's a developing Cold War really between China and the United States, and the incoming US administration is going to be out of step with the EU on everything to do with platform, economy, privacy, etc., etc. So what's the basis for your optimism?
So just to make it clear, I'm not optimistic. As I said, that's the dream. That's a dream. The hope is that we're going to get guidance material and usable and practical information for states. That is, I agree. I think it's too optimistic to think that there would be an international agreement at any time soon on this type of issue. It'd be very optimistic to think that there is an international agreement in the aviation sector at this stage right now. It takes years and years and years for any kind of international, for example, even amending the Chicago Convention. It's different. But perhaps there could be something that gives guidance and help to states. That doesn't mean that it might not be on the agenda, or it might not become part of the facilitation annex in a way that is potentially easier to get to. So I have no reason to be optimistic that treaty work is going to happen. I didn't mean to come down like that. I was being quite
Let's get back to the
positive.
show. Let's get back to the show.
I don't need to come down.
Kathy, you have a question.
So what do airlines do in the meantime? They pick kind of one regulation and they hope for the best?
Well, our airline members have to manage their businesses. They have to comply. They have to comply wherever they're going. They have to make decisions on where they're traveling to, based on what are the compliance issues, what are the information that needs to be done. So it's something that is managed, but it is increasingly more and more difficult to do so. And as I mentioned, there are fines for not complying. There are fines for not providing the PNR data.
Do you see certain states or blocks that are a little quicker to give fines, or say they haven't been compliant?
Well, there have been fines in various states. I mean, although not directly related to the privacy protection issue, but more to the collection of fines issue. There were fines in Poland in the last few years related to the inability for technical solutions to enable the provision of PNR data. There were significant fines, and those were there was a kind of waiting period on those. But that's not an example that suggests that, for example, that Poland is more inclined to provide fines. I think it was it's a kind of a technical issue and a legislative issue, a procedural issue that needed to be addressed. There are fines. One of the things about fines is they may exist, but are they enforced? And I think that's something that, with us, with the work that we're doing to make this issue known and making states think very seriously about enforcement in the context of information that's required for safety and security, for example, we're hoping that that's something that might be discouraging enforcement activity. But as you can imagine, too, for our airline members, enforcement is a sensitive topic. It is a sensitive topic.
Okay, thank you very much.